All right, and live. Done and done. All right, so my name is Chris Berry with Castle Wealth Group. Every week we do these weekly wisdom webinars where I answer your questions live. And you can either submit questions ahead of time. So a lot of times I have people email specific questions covered on the webinar ahead of time, which I prefer. Or you can always go ahead and just ask while we're going live and putting it into the Q&A or the chat. And okay, done and done. And I always like to start with positive focus, something positive that happened over the previous week, either professionally or family related. At times it's family related, especially my kids, they're super cute. But this week, I'm multitasking as I do this, and I'll put it into the chat. Had a new book published, finally came out. So Retirement and Legacy Blueprint. It is now finally available on Amazon, where we talk kind of legal, financial, and tax planning, like all the things that we talk about here. But I put it into book format. So this is the second book that I've written, and I'm going to put it into the chat. You can email us for a copy, or if you want to go to Amazon, you can download it or get a copy there. And then if you leave a wonderful review, that would be awesome too. But yeah, my positive focus is our new book. I just put it to panelists. I want to do it to everyone. Panelists and attendees. Boom, there we go. So that is my new book. Last one was a caregiver's legal guide to planning for a loved one with chronic illness like Alzheimer's, dementia. I think I wrote that in 2014, 2015. So this is my second book. All right, so that's my positive focus. Now let's get into why you're actually here, which is your questions. I don't have a lot this week, so if you do have questions, please put it into the Q&A so I can take care of it. And let me share my screen. So I hit this button, I hit this button, hit this button, and then I hit this button. All right, so again, this is, like always, this is general advice. If you want to see how it applies to your specific situation, make sure to schedule some time on the calendar. First question, and again, if you do have questions or anything you want me to discuss, please make sure to put it in the Q&A or the chat, because I don't have a ton this week. So whatever burning questions you have, let me know. Is it possible for an executor to forego probate for a small, uncomplicated estate? Estate is an IRA of about 27,000, checking account of 5,000, and a will exists with assets distributed evenly to the kids. So really what we're talking about here is, can we avoid probate, and how does estate administration work? So big picture, understand that when someone passes away, there's only 4 ways that assets can transfer out of their name. And we call this estate administration. So how do assets transfer upon death? So first would be joint ownership. So a lot of times married couples, they own a lot of things jointly, like real estate, checking accounts, savings accounts. One spouse passes away, everything goes to the survivor. Pretty darn straightforward. Joint ownership is great for married couples, but I wouldn't name your kids jointly on real estate or anything like that. I had a woman come in. She just created her own, created a deed herself, submitted it at the county, naming her kids jointly. Creditor action, bankruptcy, mom might lose that asset, lose that account. And then the other thing is that she's losing some tax benefits. Like when someone passes away, if the asset passes through a trust or even through probate, you get what's called step up in basis, where now the tax basis, if you were to sell it, is what it was at date of death versus what you originally purchased at. By doing it through joint ownership, you lose that step up in basis. And now if the house is purchased at 100,000, date of death it's 200, the kids sell it for 210, the kids will have capital gains of $110,000 versus if they do it through like a ladybird deed or beneficiary designations, something other than joint ownership, they would have the step up in basis where now it's just the date of death versus the amount sold. So joint ownership, great for a married couple. I don't recommend it typically for anyone else. Second would be through beneficiary designations. So you list a beneficiary on your IRA, your 401k, your checking account, your savings account. You can do ladybird deeds to say the home is in your name and then upon death goes to whoever you've named, thereby avoiding probate. 401ks, very straightforward. It's just a pillowcase of money. You're just giving a pillowcase of money to whoever you've named as a beneficiary. Third would be through a trust. And so there's different types of trusts, of course. We have revocable living trust, we have legacy trust, we have castle asset protection trust. So there's different types of trusts. But if an asset doesn't pass through one of those first three ways, then it ends up going into probate. And really, probate, there's two versions of it. And if you notice, I didn't mention a will because all a will does is gives instructions to the probate court. So if you want to avoid probate, you don't want to rely on a will. All a will does is it gives instructions to the probate court on how to administer your estate. So when you do get into probate, there's two options. And understand that probate, it's not just talking about like fighting and litigation, that type of thing. It's just a court process to administer the estate. And one version is what's called a small estate. And basically what you do is you get an affidavit, and this can be wrapped up in one day, but basically you get a small estate affidavit saying that, hey, I paid the funeral expenses. Here's a copy of the paid funeral. And then they will issue a letter of authority saying that, hey, you now have authority as that survivor to be reimbursed for those funeral expenses and wrap up kind of their final affairs. The small estate affidavit procedure is capped at roughly $20,000. It's been increased for inflation, so I don't know the number right off the top of my head, but it's about $20,000. So if you have a loved one whose assets don't pass through joint ownership, beneficiary designation, trust, then they're going to end up going into probate. And if those assets are less than roughly $20,000, then it avoids probate. The other is just full on probate. And now you're talking about, so small estate affidavit, this can be wrapped up in a day. And you're probably looking at maybe, I forget what the filing fee is, but I'm guessing anywhere from $300 to $500 total to wrap it up. Okay. Versus full on probate, you're looking at a 5-month process at the very minimum. And typically it's about 3 to 5% of any assets going through probate get eaten up in costs, whether it's inventory fees, filing fees, publication fees, or sometimes attorney fees. So yeah, we always want to avoid probate, but if the value is less than roughly $20,000, then you can get away with a small estate affidavit procedure. In this situation, if we have an IRA, I guess if there's an IRA, I'd find it hard to believe that there wasn't a named beneficiary. So I would double check that because that would avoid probate. And then if there's a checking account with 5,000 that there isn't a beneficiary, then this would go through that small estate affidavit procedure. I'm guessing the IRA probably does have a beneficiary. I'd be hard pressed to find, well, unless someone predeceased, but it'd be hard pressed to find a situation where someone had a account open like an IRA or 401k and didn't have a listed beneficiary. Like it happens, but I would say it's relatively rare. So hopefully in this situation, the only thing that's really hanging out there is just that checking account. And again, there's two things that I would say typically we see people miss when it comes to this process of joint ownership, beneficiary designations, trust. And those two things are typically real estate. Like people forget to handle the real estate. and then they don't handle the checking and savings. With the checking and savings, I always recommend that you have a beneficiary, and banks are going to call it either transfer on death or payable on death. Means the same exact thing, but you should always have a beneficiary on those checking and savings accounts. With the deed, typically we're doing either a ladybird deed or we're deeding it directly to the asset protection trust, to the castle trust. But those are the two things that people kind of forget about as it relates to estate planning and then end up going to probate. Typically like IRAs and 401ks, a lot of times people just have beneficiaries on those. When is a ladybird deed set up? So talking about a ladybird deed, and a ladybird deed is a type of deed to say that it's in your name while you're alive and well, and then upon death, it goes to whoever you've listed on that deed. So it's like a beneficiary designation for your home. So like you have beneficiaries for your 401ks, your IRAs, your life insurance, a ladybird deed is basically a beneficiary for your home to say it's in your name while you're alive. You can refinance it, you can sell it, but then upon death, it ends up going into the trust. So the deed is activated or signed right away, and it's recorded at the county. But then when you pass away, then your beneficiaries walk in with a death certificate and transfer it to whoever's listed on that ladybird. And so either in our office, we're doing a ladybird deed, or if we set up an asset protection trust like a castle trust, then we're deeding that property directly to the trust. So we wouldn't do a ladybird deed. Is a castle trust the same as a irrevocable trust? Can the creator of the trust also be a trustee? Yeah, so a castle trust is a form of irrevocable trust. It's a trust you can make changes to. You can be trustee of the trust. You can decide how the assets are invested. I just met with a woman, hypothetically, whose husband has Parkinson's. We set up a castle trust about 3 years ago, and we moved the majority of her assets into the trust. And now we're a couple of years into the trust with the idea that once we make it 5 years, everything inside of the trust is protected from that nursing home or Medicaid spend down. And so we are just talking about how that works. Can she change the nature of the assets in the trust? And she can. She's the trustee of it. She decides how it's invested. If she wants to go from Google stock to Apple stock, she can do it all within the trust. So she's in control. But what makes it special is that it protects from the nursing home or Medicaid spend down. Here's another question. How do you move money around to protect assets when one spouse needs medical care, assisted living, nursing home care? Ideally, well, there's legal strategies and then there's financial strategies. So the legal strategy is what I just explained, is we set up the trust, we move assets into the trust. Ideally, we can make it 5 years before we need a nursing home. Everything inside of that trust is protected from that nursing home or Medicaid spend down. And then there's certain ways that we should probably invest inside of that trust, just from a tax perspective as well. That was something we were talking about a little bit. So we can build in these legal protections, kind of building a wall around your stuff. Then there's also, if we're planning ahead, there's financial options as well, and insurance options. I wouldn't recommend like pure traditional long-term care insurance for a variety of reasons, but there's different opportunities we have in terms of how you structure your investments, where some tools have a death benefit that could double as a long-term care benefit to help pay for home care and assisted living. There's some tools that if you have income coming in monthly, that income could double if you're to need long-term care. But yeah, in the earlier you start thinking about planning for long-term care, the more options you're going to have. And I think that's something that really our office does an outstanding job of, is helping clients protect, plan, and preserve what's important to them, and developing plans to protect against the devastating cost of nursing home care and assisted living. Like I said, I met with hypothetical woman just before I got on the call. She's been caring for her husband. She's looking at bringing home care, not just for her or not just for him, but to give her some respite so that she can go to Lion King with her sister. I have a conversation with the hypothetical client tomorrow. We've been talking, we set up an asset protection trust and we have a chunk of change, and we're talking about how can we leverage that money because his wife has dementia. So the earlier we start planning for these things, the more options we're going to have on the table. But a lot of times it's custom to your specific situation. There's no like magic wands or perfect tools. So it's really figuring out what are your goals and then developing the best strategy and then picking the right tools. All right, another question here. When does the 10-year IRS period start for inherited IRAs? Yep. So we're talking about IRAs, and let me go back to sharing my screen real quick. This time I don't need someone to remind me to share my screen. I'll actually remember to share my screen. All right. What if you need to protect assets at the last minute when a spouse needs it? Okay. Yep, I'll get to that in a second. Let's go. All right, so we'll jump ahead. So we're talking about IRAs, and IRAs are what we call qualified accounts, meaning there's some type of tax qualification to them. Okay, and you have to be the owner of your IRA. Okay, a trust cannot be the owner. You have to be the owner of your IRA. I had a conversation with a woman this morning about that. She said, "Oh, mom's IRA is in the trust, and I'm the trustee. I should be." It's no, you have to be the owner of your IRA. But and then what happens, and this is due to the Secure Act, which passed in 2020, is that at age 72, that year you have to start taking out required minimum distributions, RMDs, and it's roughly about 3.6% of the account value, and it goes up every year. And then when you pass away, so upon death, if you leave it to anyone basically other than a spouse, then what happens is there's this 10-year rule where all the taxes have to be paid within 10 years. So if you're sitting here and you have your IRA, okay, and then God forbid you pass away, and now you're leaving it to, whoops, let's draw that in blue. Now you're leaving it to kids. They each get that IRA, and then they have to pay the taxes within 10 years. Okay, so if that's like $1 million, each kid gets 500,000. They can stretch it out up to 10 years, but they have to pay the tax on that within 10 years. Okay, so the 10-year rule with regards to IRAs are triggered upon death. Here's another question. What if you need to protect assets at the last minute? When a spouse needs nursing home care, how do you move money around? So we're talking about nursing home care. And yeah, the average cost of nursing home, like right now, we're looking like $10,000 to $15,000 per month. And current statistics say 1 out of 2 individuals will need nursing home care. And currently the average stay in nursing home is about 2.5 years. So that's why this is a big concern for a lot of my clients and why they're asking a lot of questions about it. And so when we're concerned about long-term care and nursing home care, there's really 2 routes. One is we can pre-plan. So plan ahead, and that's what I prefer. And this is where we do things like the Castle Trust. This is where we do things like asset-based long-term care, or we can operate from a crisis. Okay, and I do have people that come in and they hadn't done any planning, and now all of a sudden mom or dad has a stroke, is in a nursing home, and they're concerned about what to do at the last minute. And when we plan ahead, potentially we could protect up to 100% of the assets. Like, let's say we plan ahead, we move our assets into that asset protection trust, Castle Trust. We make it 5 years because Medicaid has a 5-year look back period. then 100% of what's in that trust is protected from that nursing home or Medicaid spend down. So now we can have Medicaid pay that base level care, and then we have a pot of resources to pay for additional services to improve quality of life. So that's where we try to operate as much as possible, as plan ahead, but we know that not everyone plans ahead. So we still have what we call crisis planning opportunities. And as a certified outlaw attorney, I think there's 17 of us in the state of Michigan, maybe 500 across the whole nation. These are two things we really specialize in, is the planning ahead for long-term care and then the crisis planning. So if we're doing crisis planning, one strategy is what we call a half loaf plan. Okay. And this is what my first book, Caregiver's Legal Guide, talked a lot about these types of strategies. And if you want a copy, just reply or send us an email with your address, and we can put a copy in the mail where it goes into more detail. But a half loaf, like think of it like a loaf of bread, where we can protect half of the money, because normally Medicaid would make you spend down to $2,000. But what we can do is we can protect half the money. So let's say we have 400,000, half of the money can be protected. The other half would have to go to the nursing home over time. It's kind of complicated how we do it, but just understand that, yeah, God forbid you or a loved one need nursing home right away. There's things we can do at the last minute to protect at least half of the assets. So with crisis planning, we can typically protect at least half. By planning ahead, we can protect 100% typically. So we much prefer planning ahead, but God forbid you have a loved one in a nursing home, there's things we can do still at the last minute to try to protect at least half of those assets. How do you plan ahead to protect IRA assets against long-term care? So getting back to IRA, really there's get rid of this. So how to protect IRA money. I would say that right now there's two main strategies. I guess three main strategies. So one is pay the tax and get out of the IRAs. And I have a ton of people doing this now because they think taxes are going up in the future. So we're looking at these pre-tax accounts and knowing that we are operating with regard to the Tax Cuts and Jobs Act that runs from 2018 to 2025. And we know taxes are going up in the future because when that Tax Cuts and Jobs Act expires, which is scheduled for 2025, taxes across the board are going up 3 to 4% at the very least. That's current law. And then we look at the amount of debt this country has, which is now approaching $30 trillion. And so there's concerns with taxes going much higher in the future, because also we're at the lowest ever historical marginal tax rate, ever. The lowest historical marginal tax rate. Like taxes have never been lower than they are right now. And our federal deficit has never been higher. So most people say there's like three options. One option is the government's going to print more money, which they're already printing a ton of money and inflation is skyrocketing right now. Like your Social Security is going up 6%. Now you're not getting 6% because your Medicare payment is going 6%. But that's the highest jump since 1980. So we could print more money, but that's not a perfect option. Government could cut spending, especially in the pandemic. We went from $22 trillion to $29 trillion in a year and a half. So that's not happening. And it's on both sides, not to get political. Both sides are spending. They're just spending on different things. Or third, we can raise taxes, which doesn't sound great, but that's what the Secure Act was. That was passing what I call some stealth taxes, where they're not raising the taxes on you. They're raising taxes on the inheritances, or what the beneficiaries are inheriting through the IRAs. That was kind of a warning shot of, you know what, the government's coming after those pre-tax accounts. They're not coming after yours while you're alive. They're coming after it when you pass away. But I think that's a warning shot to say, the government is aware that there's $26 trillion sitting in these pre-tax accounts, like IRAs. And when the Secure Act passed, we were $22 trillion in debt. So they said, okay, you know what? We're not going to come after them now, but as these people pass away, then we're going to get all this tax revenue. That's why they passed the Secure Act. Well, that was when the deficit was $22 trillion. 2 years later, we're now at about $30 trillion. So long story short, how do we protect the IRAs? First is, I would say, you know what, let's pay the tax and move the money out of the IRA. So now we're out of that partnership with IRS, and we can do things like move the money into a castle trust, right? So let's pay the tax and now move it into something that's protected. That's something that the woman I was meeting with today, we were talking about, she still has IRA money, and we moved some last year, and we're going to move some more this year to then invest it in the trust. And if you like XYZ mutual fund inside of your IRA, you can do the same thing inside of your trust. So I would say the majority of what we're doing is we're paying a tax because that makes sense from a tax perspective. And then also now from an asset protection standpoint as well. Second option is what I call asset-based long-term care, where let's say we have, and I'm just making up some numbers right now. Let's say we have $1 million of IRA money. What we could do is we could keep 700,000 kind of in the market, but then let's carve out or chip off 300,000 that, based on your age and health, could be a $600,000 long-term care benefit / death benefit. And yeah, this is using like insurance type products to do this. So that would be another strategy, is chipping off a portion of the IRA. Now, you've turned like 300,000 into $600,000 of long-term care benefits. And then if you don't use it, it could be a tax-free death benefit to your beneficiaries. And then third, and we've talked about this before, would be income solutions. Okay. So let's do the same thing. Let's say we have $1 million IRA. Okay. And I'm just, again, making up numbers here. So let's keep 500,000 liquid. Maybe the remaining $500,000 is turned into an income stream for your life. That's saying, okay, you're going to get $50,000 a year of income. But then if you were to need long-term care, that doubles. And now you're getting $100,000 of income for long-term care. So those are both kind of insurance, financial insurance-based solutions. This has underwriting, so you have to be relatively healthy. This has no underwriting. You just have to wait about 2 years before you trigger it. So how to protect the IRA from long-term care costs? First, and this is the way most of my clients are moving, is they're moving money out of the IRA for tax purposes, and then also from just for asset protection standpoint. And it's kind of a different thought, like, but I'm not sure why more people aren't talking about that. And whenever I've had conversations with someone, like they have their own accountant or CPA, by the time we have that conversation, they're always on board. But just sometimes there's some pushback against that for some reason. All right, a couple of questions here. Besides money in a trust, what assets do not get counted for Medicaid? Okay, yeah, so if you pay the tax and put it in the Roth IRA, does that count? Okay, so we're talking about Medicaid. So if you need a nursing home, which ideally you don't want to be in a nursing home, but medically sometimes you just have to be there. They allow you as an individual to keep $2,000 to keep your house, but they can place a lien on your home. You can have up to $1,500 of cash value life insurance. You can have a car. It's me drawing a car. See how it turns out. Not great, but that's a car. And then you can have personal property. So if you need nursing home care and want to qualify for Medicaid, oh, and then you can have a irrevocable funeral contract. So you can have $2,000, a home up to $500,000, cash value of life insurance of up to $1,500, an automobile, personal property, and then an irrevocable funeral contract. Everything else is a countable asset. So 401ks, IRAs, Roths, etc. And then if you're married, your spouse at most, so if one spouse is in the nursing home, so this is the nursing home spouse, and then if one spouse is in the community, they can have anywhere, depending on the situation, from 30,000 up to at most $120,000 of assets. Okay, so this is, we call this, the technical term is the institutionalized spouse. This is the community spouse. Okay, if we're single, then you're just institutionalized spouse. So you can have $2,000 and personal property, automobile, life insurance, irrevocable funeral contract. If you're a married couple with one spouse in the nursing home, they can only have the $2,000. At most, you can have $30,000 to $120,000, depending on the situation for Medicaid purposes. So yeah, 401ks, IRAs, Roths, those are all countable assets. And so when we're doing Medicaid crisis planning, if you have those, a lot of times we have to pay the tax. And I'd rather pay a little bit of tax now to protect against the $10,000 to $15,000 a month nursing home bill. So yeah, it's not perfect, but I'd rather pay a little more tax to save tens of thousands on long-term care costs. All right. And again, if you do have questions or thoughts, put it into the Q&A. Last one I have here. If you pay the tax and put it into a Roth IRA, does that count? Not quite sure what we're referring to. That makes sense from a tax perspective. Yeah, like Roth conversions, getting money out of those IRAs, I can't stress that enough. That is right now the biggest, I would say one of the biggest risks and biggest opportunities. Biggest risks because of all the reasons I said about taxes. Like if you're not thinking about tax planning, you're really missing an opportunity right now. How much does it cost to do last minute protection of 50% of the assets? A lot. It's not fun. So if we're doing nursing home Medicaid crisis planning, typically we charge about 2.5 months worth of nursing care. Because when we submit a Medicaid application, the actual application is only about 6 pages. But when we submit a Medicaid application, you're looking at sometimes we're submitting about 150 pages worth of documentation, because we have to step by step show the caseworker exactly what we did. And it's legal, but we're just using the rules to maximize your resources, but we have to document it. So yeah, usually you're looking at about 2.5 months worth of nursing home care is the fee for us to do a Medicaid crisis plan. So, and again, planning ahead, much simpler, much less stress, and less of an investment as well. So again, the earlier you start thinking about long-term care, the better off you're going to be. And especially with the Medicaid rules. The Roth IRA question was regarding your discussion on protecting the IRA. You said to pay the tax. Oh, yeah. So it was clarification on the Roth IRA. So yeah, I think right now, I think there's 3 big risks right now. The first is market risk. We've seen that last like day or two. But overall, we've been on a 13-year bull run. And there's a lot of craziness going on. So having a 2008 or 2002, there's a lot of red flags for something like that. So market volatility is a big risk. But that's always a concern. But right now, I think, at least with the clients I'm talking to, the 2 other big risks are long-term care risks, with the idea that we're living longer than ever. And this isn't something that's new, but I would say within the last 15 years, we've seen like our parents needing care, and now we're seeing like, oh, they don't have anything in place, or they're living longer. spouse has dementia or Parkinson's, things like that, long-term care. And then the big one, and this is a window of opportunity based on the current tax laws, is tax risk. Is just, I can't stress enough, we're at the lowest historical marginal tax rate ever in history. And we're about $30 trillion in debt. And the way the current tax laws are, taxes are scheduled to go up. That's the way the current tax laws are. So I think everyone should be looking at their tax brackets and making intelligent decisions about how much. It's really a two-step question: how much to move and where to move it. And so, yeah, pull money out of the IRA, put it in a Roth. That's great from a tax perspective. And that's the most common way that people get money out of those pre-tax accounts is through Roth conversions. Roths are relatively new, and there's certain rules around contributions, but Roth conversions are pretty straightforward. Here's another question. If a deed for a second home is in both husband and wife's name as tenants by the entirety with full rights of survivorship for Medicaid and nursing home. Okay, all right. So the question is, we have a second house and it's husband and wife, and is that protected from nursing home or Medicaid? And the answer is no. Only one residence, your primary residence, is protected. Any second pieces of property, third pieces of property, rentals, those are countable assets. It doesn't matter whether there's a ladybird deed or anything. If it's in the asset protection trust, it's protected. But if it's just in husband and wife's name, just like a primary residence, no such protection. So yeah, the primary residence is protected up to 500,000, adjusted for inflation. Second properties or anything else are not protected. All right. Any other questions? Thank you. You are welcome. All right. Going once. Hold on, let me pull up the Q&A. Cool. All right. Answered everything. Good questions. I appreciate it. All right. Take care, everyone. Make it a great week. See you next week. Thank you. Thank you. Thank you. Thank you.